to be bound by the NCAA, even if it is a cartel?
Well, it's the only game in town right now. It'd be very tough to go elsewhere, although I do think that that's something that needs to be studied. You talked, Mr. Scott, about who is the final decision maker. You mentioned the term commissioner. I do often sometimes chuckle at that, even in professional leagues where commissioners actually work for the owners. Had a very distinguished athletic director tell me about the current president of the NCAA, Dr. Miles Brennan, saying very clearly to me, he said, Dave, he works for us. Now, while he might be trying to do some good things, the bottom line is he still works for the constituency that wants to make the money, and that's where the conflict arises.
Well, who should be, if it's not the NCAA as the final arbiter, who should be able to have the final decision?
I really truly believe it's time for faculty to take charge of their own institutions and take charge of intercollegiate athletics on their institutions' campuses. I'm associate director of a national consortium of faculty and staff for true intercollegiate athletic reform called the Drake Group. And I do believe once faculty take control and enforce academic standards on their campuses, it will almost eliminate the need to have an NCAA governing body because those standards will be enforced by tenured faculty at their institutions, and just by happenstance, many of the problems that we have today will evaporate.
Well, you asked us to do the right thing. How is, somebody said, maybe Harry Truman said, doing the right thing is easy. Figuring out what the right thing is the hard part. What is the right thing for Congress to do?
What I would like Congress to do, and specifically, there's many other things, and I know I'm off on a little tangential area here talking about athletic reform, specifically on the NCAA infractions and enforcement process, break down the shroud of secrecy, bring true independent oversight to that committee, and guarantee fairness and due process for all.
Wait a minute, and exactly how do we pass a statute? What statute would we pass to require the NCAA to adopt specific rules and regulations? And how are we assured that they actually follow them?
Well, to be totally not really quite sure I can answer that question, sir, in that I'm not quite sure what Congress can do, and that's what I'm here today to hopefully look at different proposals. I don't know what type of law can be enacted. I don't know what type of oversight can be done on an independent organization, but I do think, on a voluntary organization, quote unquote, but I do think that Congress needs to look at and explore situations and potential statutes and legislation that can actually give a check and balance to a process that right now has absolute power and has no check and balance in place.
Ms. Patuto, you have an antitrust exemption, specific antitrust exemption, is that right?
No, there is no antitrust exemption.
The NCAA doesn't have an exemption under the antitrust laws?
I don't believe so.
Okay. No further questions.
The gentleman's time has expired. The gentleman from Iowa, Mr. King, is recognized for 5 minutes.
Thank you, Mr. Chairman. And I'd point out, since the chair has identified me as the gentleman from Iowa, my focus does come on the Tim Dwight case. And I'd ask one short question, Mr. Bloom. And since in your written testimony, there's not identified to be, to your knowledge at least, a distinction between the Tim Dwight case and your case. And so since those decisions came down exactly opposite, could you inform this committee as to why you believe those decisions were opposite one another?
I have no idea, and they have no one holds them responsible to explain. The congressman from Iowa is bringing up Tim Dwight. Tim Dwight was a junior at Iowa. He went pro in football, signed endorsement deals his junior season, filed for reinstatement his senior year to return to Iowa to run amateur track. The NCAA allowed him to do so and stated that his football ability was the reason for those endorsements. I'm a professional skier on the Olympic level. I must have endorsements to be able to travel the country. I did the exact same thing as the University of Colorado did the identical, filed for the identical reinstatement request as the University of Iowa did. I was denied. He was allowed. I have no explanation. They didn't talk to me. I have no paperwork. Nothing.
Thank you, Mr. Bloom. I would yield the balance of my time to Mr. Backus from Alabama.
again, too. Well, hello? Oh, there we go. Professor Patuto, you've, in your statement, you stressed timely and efficient resolution as one reason for not, I think you have in the past, for not having open hearings or public hearings. Is that one of the considerations?
Yes.
Now, I noticed this emphasis on the cost of it, not having public hearings and not having people allowed to confront the witnesses against them, and that thing. You took the same tact, I think, in opposing Title IX, the continuation of Title IX as it related to women participation in athletics. Is that correct?
Congressman, I'm not sure I understand what the reference is.
Well, I'm reading an article where cost of Title IX now outweigh benefits by Josephine Patuto. Is that the same? Are you the same?
Yes, yes.
Where you say in there the cost of implementation of Title IX are heavy and outweigh the benefits they have produced?
I did say that, but I wasn't
Now-
referring to economic costs, Congressman. I was referring to the impact on male student athletes who are interested in competing even without scholarship.
I just, it says cost, and I wondered
Yeah.
what that meant. I appreciate that. But you're opposed to their continuation, even though you realize that they brought about a sea change in respect to women's opportunities.
I'm not opposed to the continuation of Title IX, Congressman. I support a relook and adjustment to reflect the equities and interests of both genders.
So you've changed your, at this time, you are not for the continuation, right?
No, I've never said in any written or public statement that I'm not for the continuation of
Okay.
Title IX.
All right, let me ask you this. In your statement, when you talk about the reason for not having public hearings, you mention it mentions a reason not to have public hearings on page 8. Extreme public interest among media and fans might create difficulties in maintaining an appropriate hearing atmosphere.
That's right.
So one reason not to have an open public hearings is extreme public interest?
It is. It's not the only reason. It's probably not the dominant reason, but it certainly is one reason.
But one reason not to have an open hearing is the public's interest in the hearing.
Yeah, the public's extreme interest in a hearing that can not only affect the atmosphere of the hearing, but may well have an impact on those individuals who are not associated with institutions, who come forward with probative information and then are thrust in a media circus and held up to scorn and pressure in their own home communities.
You're aware of even Supreme Court, you teach constitutional law, you're aware of the number of cases and a number of legal philosophy that public awareness, public interest should be encouraged, and that actually it has a cleansing sunshine laws, for instance, effect on hearing?
Yes, Congressman, and I'm
But-
also aware that public institutions, when they're looking at disciplinary actions against faculty, dismissals, promotion and tenure decisions,
Well, we're not talking about that here. We're talking about, let's say, an athlete, and the athlete, like Jeremy Bloom, wanted to appear before the committee, wasn't even allowed, but had he been, these are private hearings. What if the athlete or the coach under investigation says, I want a public hearing?
First, if we're talking about the Committee on Infractions, there may be
Gentleman's
several.
time has expired, but you can answer the question.
There may be several different individuals, in addition to the institution, that all have varying interests as to what they want. Mr. Ridpath talks about an impact on his reputation. I do not see that a public hearing would alleviate or ameliorate that kind of impact. If we're talking about a student athlete, I'm not in the best position to describe the process as it affected Jeremy Bloom. We have here a member of the student athlete reinstatement staff that dealt with it, who can give particular information and I think challenge the information that Mr. Bloom describes in terms of the processes available to him and his opportunity to participate fully and at several stages in the process. And I might add, before several different committees.
The gentleman's time has expired. The gentleman from Tennessee, Mr. Jenkins, is recognized for 5 minutes.
Thank you, Mr. Chairman. Professor, I have a poor copy of the judge's ruling in the District Court of Colorado, and it appears to be incomplete, but what was the basis of the judge's ruling in that case, and why was Mr. Bloom denied?
Mr. Congressman, that's a student-athlete reinstatement issue. I can't sit here and tell you that I have recently read that particular opinion so that I can share with you the particulars. But having said that, the judge, as I recall that opinion, upheld the NCAA's opportunity to self-police and to administer its programs as a private institution. It granted Jeremy a status before the court in order to reach the merits and then find that there were no substantive procedural issues and that fundamental fairness was provided.
Have the courts across the land ever, in any cases, found that the student athlete had rights, and they have proceeded to enforce those rights?
Not that I'm aware of. As you well know, Mr. Congressman, in order to reach procedural due process issues as a legal constitutional principle, the individual challenging has to have a substantive property or liberty interest. The opportunity to play intercollegiate athletics does not rise to that level. In Mr. Bloom's written statements, he talks about the deprivation he's suffering because the college athletics are a minor league for the pros. Well, I would dispute whether any intercollegiate athletics program sees itself as simply or even partly training athletes to be professionals, although that may well be a side effect of playing intercollegiate athletics.
Well, this may be a question that would be more appropriately addressed to Mr. Bloom, but from Mr. Bloom's testimony, it states on the second page, in January of 2004, I announced that I was beginning to, it says accept, E-X-C-E-P-T, I assume that means to accept endorsements and plan to play football for the University of Colorado. And maybe Mr. Bloom. Mr. Bloom, is that, did you make that decision on your own with full knowledge of what the rules were?
Yes, I did. And in 2004, I had spent 2 seasons foregoing any type of money coming in from companies. And the NCAA does allow me to receive prize money, which if you win every competition in the year, you're not going to be able to pay for your competitors.
So you set out to be rebellious and a pioneer and to challenge this rule that you knew very well. That was very clear. Is that correct?
I don't believe I set out as a pioneer. I set out as an athlete who has dreamed every day since I was 5 years old of winning a gold medal in skiing. And when my athletic career was put in jeopardy because of the restrictions placed upon the NCAA, I was put in no other position to accept endorsements and keep my ski career alive.
But if you had made the decision not to accept endorsements at that time, you would not be here today, and there would be no difficulty with respect to the future for you.
I would not be here today. I'd be with the University of Colorado football team, and I would be retiring from the sport of freestyle skiing.
Now, Dr. Ridpath, I was unclear after Mr. Backus's questions about you asked us clearly to intervene, and you outlined after Mr. Scott's question, some of the things that you would want us to do. Now, you know, you're kind of bucking a trend too. Most people come up here to the Hill and they ask the Congress to keep our nose out of their business. And are you sure now that you want us to intervene and to do the things that that you would ask of us to do now and get into this?
I'm absolutely convinced, Mr. Jenkins, and it's not just me. It's the Drake Group, of which I'm a member of, the Knight Commission on Intercollegiate Athletics, the Coalition on Intercollegiate Athletics, several outside groups that have reviewed intercollegiate athletic policies and procedures. We're at the level right now that government intervention is the only way to stop this train. We are heading for a train wreck.
What about your suggestion that it's time for the schools themselves to take control of this and
The gentleman-
do the reforms that are needed?
The gentleman's time's expired, but you can answer the question.
Well, I wanted to say that the only people that have the power to enforce true academic standards, true standards that enforce college students, real college students playing college sports, students like Jeremy Bloom, are the faculty. And right now the faculty are completely out of the process. The only faculty that are involved are ones who have a vested interest in athletics. But I do want to say on my public hearing issue that I said throwing sunshine on the process, to respond directly to Ms. Batutu, it would have absolutely ameliorated my process because it would have exposed how the committee acted, their unprofessional, caustic, and adversarial attitude, and how I was completely railroaded. I don't think they would have acted that way if it was a public hearing.
The gentleman's time has expired. The gentleman from Alabama,
Mr.
Mr.
Chairman,
Box.
I believe the lady would like to respond to that. Would it be all right if she takes the time to?
We'll give the gentleman an additional minute and let the gentlelady.
Thank you. And I also might like to add and emphasize that with regard to Mr. Bloom's particular situation, there's a member from the NCAA staff who's fully prepared to make that record clear and to correct several misstatements from Mr. Bloom. But to get to Mr. Ridpath, the committee hearing before Mr. Ridpath had no allegations against him. In fact, he was named in an allegation that the enforcement staff dropped before hearing. He was not named in the public report. There was no finding in the case made against him. He was reassigned by his employer to another responsibility in the university before the infractions report ever issued. And I would direct the committee's attention to that report if anybody thinks that Mr. Ridpath was unfairly characterized with regard to his compliance responsibilities. I stand by that report, and I would be delighted if you read that report.
We're not going to get sidetracked on this particular case here. So the gentleman from Alabama is recognized. If he wants to delve into that, he's certainly welcome to do that in his 5 minutes.
Professor, I'm sort of struck by your definition of that participation in college athletics doesn't rise, that activity doesn't rise to the level that ought to be protected by the constitutional rights or due process?
It's not my reading of that. It's, I think, the reading of all or virtually all courts that have looked at it. And I might add that the fact that it doesn't rise to a constitutionally protected interest, the fact that 9 members of the current Supreme Court says the NCAA is not a state actor and doesn't meet procedural due process does not mean that we don't provide it. There are a number, I heard Mr. Congressman, I heard you before say persons who are alleged to have violated have no right to confront their witnesses. Anybody who appears at that hearing has the right, and I can cite you the bylaw provision, to ask questions of any individual or party at that hearing.
So, so anyone charged with an offense has the right to appear at the hearing and cross-examine all the witnesses?
I don't know that cross-examining might not be the correct term for it, but certainly the right to inquire of anyone else who appears. And yes, anybody who's charged
to talk to the question of the witness.
Of course, and anybody
All right. Well, I was under
who's violation clearly has a right to appear before the
I was under the misunderstanding that you didn't allow people to confront the witness.
We do, and I can give you the bylaw provision if
Okay.
you'd like it.
Let me say this. You talk about this Supreme Court decision. Now, the Supreme Court decision said you're not a state actor. It certainly didn't give you a license to disregard people's constitutional rights, to mistreat people, to abuse people. It did, in fact, and also it did not say that the participation in college athletics was not something that was not a constitutional right. In fact, I'll give you several sites that actually say that property, guarantee of life, liberty, and property includes the right of travel, the right of enjoyment of occupation, the right to practice profession, a right to raise a family, a right to
But not the right to play an intercollegiate sport supported by scholarship at a university.
Is that right?
And Congressman, that doesn't